and a fiction going on in the state of Texas, which a lot of people believe. Even my own attorney believed it. I took this case to my attorney in San Antonio, which was an excellent trial lawyer. He looked at that and he said, Ron, they're going to eat your lunch, man. They got sovereign immunity. They can do anything they want to. And they got the Texas Tort Claims Act, man, and they're going to grind you up into powder. I said, are you trying to tell me the state has the right to kill me, take all my property and steal it or give it to their friends or destroy it without recourse to the court? That's okay? Well, he said, well, it's, you know, I wouldn't put it that way, you know. Nobody looks at it that way. But that's really what that is, or what they claim to have. State of Texas claims to be like the King of England. They did this through the adoption of ancient monarchical common law. It's a big fad right now amongst the Patriot group in Texas, Republic of Texas and others, that they want to return to something called the common law. And I used to believe that too. I went, you know, oh yeah, common law, man, that's really groovy stuff, getting to that common law, man. And instead of going into that, you know, that other court they have, that corporate court, when you go in there, you say this to the judge. You turn yourself about and you do the hokey pokey, and somehow the judge puts on a different hat and he goes over and changes the flag. He says, boy, I sure am, you know, you're pretty smart. If you hadn't have said that, I was just going to have to crucify you. But now that you learned the truth and you said the hokey pokey, I'm bound, me as a tyrant, I am now bound by your hokey pokey thing to put in the real common law of Texas. Well, guess what the real common law of Texas is right now as we speak? The state of Texas is the king, and you are the subjects, and he owns your life, your liberty, and every possession you have. And he is not suable in his own court, and he can do no wrong because all the property belongs to him. So when he goes out and harms your property, or his property, you can't sue him unless he waives it by statute or by a special congressional resolution obtained by me or you. So if you really want to sue the state for all it's done to you that harms you, you can go to your legislature, go to the Congress and say, you know, somehow get in there, make a presentation through your representative to the king, and have a resolution drafted by Congress so you can sue the state. Is that going to happen? No. That ain't going to happen, is it? So the only way you can get in there is through their little statute where they waived their sovereign immunity in 3 areas. I did like that. You can see I was publicly educated here. 3 areas. No, that's 3 areas. Okay. Here's where it is. And they put a limit on how much you can sue them for. Now, if you have a state employee, not a contractor, they already said that. No, when they hire a contractor to harm you, you deal with the contractor. Just because they sent them over there to harm you without your permission. That's kind of like it's like you and me hiring somebody to bump off your wife, you know. And you go in the courtroom, you say, "Yes, sir, Your Honor, I paid him $50,000 to do that, but he did it, so take it up with him, you know." You think that's going to fly in court? You know, forget that. But it flies in state court. So if they hire somebody to come over and harm you, take it up with them. Don't take it up with the state. So anyway, if one of the state employees runs into you, now he can't do it intentionally. He has to, if he runs into you with a motorized vehicle, you can sue him for up to $100,000. But if you prove by accident that he did it intentionally, they did not waive their sovereign immunity to intentionally harm you. So you have to draw that fine line distinction. Well, Your Honor, it wasn't intentional damage. It was kind of between negligence and an accident. So what is between well, you can see how complicated that gets. Well, the next place they waive their sovereign immunity to harm you is if you go in their office somewhere and slip and fall down, you know. They didn't somehow, they have a big oil slick and they didn't clean it up. Again, don't prove they did that on purpose. Just prove that they were kind of dumb or something. Then the next thing, you get them for $100,000 for that. And if your whole family slips and falls and kills themselves, your survivors can sue for up to $300,000. So I drew a distinction and I said, well, wait a minute. You mean if the governor of Texas decides to bomb the World Trade Center or something in Dallas and blames it on Oklahoma and goes over there and tries to take their oil, you mean that we found out about it, you mean we couldn't sue the state for that? Well, that's right, you know, because, well, if you did, let's say, yeah, you could do it if they intentionally, no, it can't be intentional. Let's say they accidentally bombed the thing. And then let's say there were 3,000 people in there. You could sue for up to $300,000. So you could split that up among all the survivors. Well, you see how crazy this is, right? Now, the other way you can sue the state is if their fountain pen blows up while you're filling out one of those forms. It blinds you or it kills you, you know. That's $100,000, up to that much. And you can see what the state of Texas did. They're acting like Walmart. They went down and got an insurance policy. You know, no telling who it's with, you know. Maybe Lloyd's of London or something. You sue them, they write their insurance agent. So the guy's really got us, you know, $100,000. Delta sends a check. Okay, so that's where, and believe me, people are believing this, you know. How many of you have ever heard the statement, you can't sue the state? Well, most people don't know why, what the philosophy behind it is, but that's it. The state's the king, at least in their own mind. Now, you see, what I proved in court, you know, and on appeal, is that that's a total fiction that doesn't exist. What we found out in court is, and by the way, the state attorneys, the attorneys for the state, admitted in their own documents that sovereign immunity is a presumption. And believe me, you're not going to believe this. How many in here know how long the state of Texas has been properly empowered under the Texas Constitution? Well, I'll give you a hint. 1 year. In 1846, it was properly constituted under the Constitution of Texas. And that says that the powers of Texas come from the delegated authority of the sovereign citizens, limited by the authority they hold in themselves to do only one thing: protect your life, your liberty, and your possessions of each and every individual in the state of Texas. And believe me, there is no other reason for forming a civil government or any other kind of government. Nobody since the dawn of mankind has ever been sold a government for the betterment of the community. We're going to build a better world. Don't you just get excited about the better world? We're going to share all of our stuff with the hungry world. Don't you want to join something like that? You know, you could share your wife too. You could give your life, you know. No, that's not what civil government is about. There's only one thing we can all agree on to even form a government in the first place. It has to be formed by consent. That's without coercion, by the way, like what we do in Iraq. You shall have democracy. You shall have our Constitution. Yeah, like, you know, great. No wonder they don't love that, you know. And what are we all going to agree on? Oh, yeah, we are. We're going to all agree that if somebody harms me in my life, liberty, and possessions, we're going to have some stormtroopers. And you just call 372-9950 and we send them over there. And we crush them because we don't want that going on. And we want to give them a lesson that you don't go fooling around with people's lives, liberties, and possessions. Now that is it in a nutshell. You take let's take 2,000 years of written history. No, 5,000. Let's go back to the Bible. Let's include that. It's about protection of life, liberty. That's why they made the kings in the first place. They made kings. They set up kings to protect the people. I don't know how they ended up with all our property with the privilege of harmonies. I mean, that's totally reversed from what we do this for. Well, anyway, to carry this on, what has happened in court, the attorneys have admitted it's a presumption. Okay, you got us, Ron. You got us on the presumption thing. Okay, when they presumed this was in a common law, back to common law, Supreme Court of Texas, 1847. This is before the Civil War, for those of you curious and think the Civil War started all this. Now, I believe there was some cowboy guys, as much as I love cowboys, I'm from that background. I believe we had some cowboy Supreme Court justices that didn't know spit about civil government in 1847. They just got off of a hot cattle ride, and that was what they were doing that afternoon. They had to do the Supreme Court thing. And they probably got in there, and the guy said, we can't have these boys out here suing us all the time. We ain't got but about $50 in the treasury. The guy said, well, I tell you what, let's just tell them you can't sue the state without their permission. Yeah, that sounds pretty good. Let's do that. Not knowing that what they did set up an entirely alternate form of government, empowering government on an entirely different notion based on ancient monarchical common law of 350 to 1,500 years ago that we had to fight all over the world to get out from under. And in fact, they don't even have it in England anymore. How many know that? There ain't no such thing as sovereign immunity in England. That's weird. And we got it in Texas? How in the world did that happen? Talk about fictions going on. Well, anyway, so in 1847, they have the Hostner versus DeYoung case where they said, can't sue the state without the permission, and only then in the manner and form that they give in the permission. Then, can't remember this governor's name, he's right before Dolph Briscoe. He says, you know, I'm thinking about this absolute sovereign immunity. It's just kind of overbearing. If somebody calls us on it, it's going to look pretty bad. Why don't we waive some of it? And when we waive it, it'll give us an extra statute and a document that somehow proves we have it. Clever. Let's obtain what we don't have by waiving what we don't have. Yeah, that's pretty slick, man. I like it. That's called the Texas Tort Claims Act, 1969. You know how many thousands of cases there are on the Texas Tort Claims Act made by the legislature? They gave me, and the attorneys for the state gave me 35 of them, quoted 35. And they said, I don't think we ought to have to quote every Texas Tort Claims Act case in the state of Texas to prove Mr. Avery is dreaming this all up. No, in fact, you don't have to file one because that's not even what I'm talking about. I don't want to hear anything about the Texas Tort Claims Act. I want to talk about the presumption behind it. And they haven't given me a single case or a single argument that touches any of the presumption that they've admitted to that lies at the foundation of the Texas Tort Claims Act. Well, so I have a motion for rehearing, and they say, denied. Oh, and let me tell you what the court said, the Fourth Court of Appeals, though they said, contrary to Mr. Avery's thoughts on this, it does exist. We decline Mr. Avery's invitation to abrogate the long-standing theory of sovereign immunity. And I wrote back to him, I said, I didn't invite you to abrogate anything, especially anything that was lawful. I asked you to prove to me the fiction that the state has power to come harm me, kill me, and take everything I have and destroy it without recourse to the courts. I want to know how that is constitutional in the state of Texas, and you didn't tell me nothing. Well, they said, denied. Motion for rehearing denied. So last Friday, I filed my petition for review in the Supreme Court of Texas. I'm claiming in there that the state of Texas has only been constitutionally empowered for 1 year, 1847. Ever since then, it's been empowered by the ancient monarchical system of ancient England. And we shall see what they say.